If you woke up this morning assuming the rules of the game were the same as yesterday, they're not. In a quiet emergency move, the Supreme Court just flipped the legal table 6-3, and millions of lives, jobs, and financial futures are now hanging in the balance, whether they realize it or not. This didn't happen with weeks of warning or months of debate on cable news. It happened fast, almost silently, and that's exactly why it matters so much. Late at night, behind dense legal language and procedural urgency, the Supreme Court issued an emergency ruling that instantly altered how the law is applied, not someday in the future, but right now. No long runway, no grace period. One decision, one vote margin, and suddenly the ground shifted under millions of people. Here's what makes this moment so unsettling. Emergency rulings are not supposed to reshape the landscape. They're designed to pause things, to preserve the status quo until full arguments can be heard. But this time, the status quo didn't survive the night. With a 6-3 split, the court allowed a legal change to take effect immediately, before lower courts could finish their work, before affected groups could adjust, and before the public even had time to understand what was happening. Think about that for a second. In financial markets, this would be like changing the rules of trading mid-session. In sports, it would be like rewriting the rulebook during halftime. And in real life, it means people who were protected yesterday may not be protected today. Programs that were frozen are suddenly active. Enforcement that was blocked is now moving forward. And the ripple effects are already spreading. What's especially striking is who this affects. We're not talking about a narrow legal technicality or a handful of edge cases. This ruling touches millions of Americans directly and indirectly. Workers, families, businesses, state governments, federal agencies. Entire systems that had been operating under one assumption are now being forced to pivot overnight. Supporters of the ruling argue this was necessary, that the law, as written, must be allowed to function without delay, that courts shouldn't freeze national policy indefinitely. Critics say the opposite. They argue this decision bypassed careful review, ignored real-world harm, and set a dangerous precedent where emergency powers become a shortcut for sweeping change. And here's the part most people miss. This isn't just about this one ruling. It's about the signal it sends. A signal that emergency orders can now carry enormous weight. A signal that legal stability can be interrupted at any moment. And a signal that if you're planning your financial future, your business strategy, or even your personal life based on existing rules, you might want to think twice, because those rules can change overnight, because the court has now shown it's willing to move first and explain later. That shift alone changes behavior. Agencies act faster. States brace sooner. Companies reassess risk immediately. And individuals, especially those directly affected, are left scrambling to understand what just happened and what comes next. To really grasp the weight of this, you have to understand how rare and powerful emergency rulings are. These decisions happen on what's often called the shadow docket. No full oral arguments. No lengthy written opinions laying out every rationale in detail, just a short order, a vote count, and immediate consequences. That's not inherently wrong, but when those consequences affect millions, the lack of transparency becomes part of the story. In this case, lower courts had already stepped in. They had paused enforcement, signaling that serious legal questions were still unresolved. Normally, that pause buys time for analysis, time for adjustment, time for the court to fully hear the case. But the emergency ruling erased that buffer. It said, in effect, we're not waiting. The P.O. Lacey moves forward now. For people watching from the outside, this feels abrupt. For people inside the system, it's destabilizing. Imagine running a business that made compliance decisions based on the pause. Imagine a state government budgeting under the assumption that enforcement wouldn't resume yet. Imagine an individual whose legal status, benefits, or obligations were frozen yesterday and active today. That's not theoretical. That's happening in real time. Financial markets understand this kind of shock very well. When rules change suddenly, risk premiums rise, uncertainty gets priced in, investment slows. And while this is a legal decision, not an economic one, the economic consequences don't ask permission. They follow automatically. Legal instability is financial instability by another name. The 6-3 split matters too. This wasn't a narrow technical consensus. It reflects a deeper divide over how power should be exercised and when. The majority emphasized authority and immediate. Sigh. The dissent warned about harm, fairness, and process. And while dissents don't change outcomes, they often read like warning labels for the future, pointing to exactly where cracks may form. What makes this especially important is timing. The country is already navigating high interest rates, tight budgets, and elevated political tension. Layering sudden legal shifts on top of that amplifies stress across the system. It forces rapid adaptation at a moment when resilience is already stretched thin, and yet, For all the noise this decision should be making, many people still don't realize what just happened. There was no primetime announcement, no emergency press conference, just a ruling posted, a clock started ticking, and lives quietly rerouted. That disconnect between impact and awareness is where the real risk lives. Because when people don't see a change coming, they don't prepare for it. And unprepared systems break faster than flawed ones. This is where part 3 really matters. Because now we're moving from what happened to what it means going forward. This emergency ruling didn't just activate a policy, it reset expectations. Lawyers now have to assume that pauses granted by lower courts may be temporary at best. Agencies are learning that if they push hard enough, fast enough, the highest court might let them move before the debate is finished. And that changes incentives. It rewards speed over caution, momentum over deliberation. For individuals caught in the middle, this creates a kind of legal whiplash. 1 month you're told to wait, the next month the wait is over, whether you're ready or not. That unpredictability erodes trust. Not just trust in courts, but trust in planning itself. People stop asking, what's the rule, and start asking, how long will this rule last? There's also a longer-term institutional effect that doesn't show up in headlines. Emergency rulings like this accumulate. Each one lowers the threshold for the next. What was once extraordinary starts to feel routine. And when emergency tools become normalized, they stop being safety valves and start becoming levers of power. From a financial and analytical perspective, this is where caution lights up. Systems, whether legal or economic, rely on stability more than perfection. Investors can price bad policy. Businesses can adapt to strict rules. What they can't handle easily is sudden reversal. Overnight activation. Rules that exist in limbo until they don't. The dissenting justices made this concern explicit. They warned that the harm isn't abstract, it's measurable, it's borne by real people in compressed timeframes. And even if the policy ultimately survives full review, the damage done during that interim period can't be undone. You can't rewind weeks or months of enforcement. Supporters will say this is simply the law working as intended, that emergency relief should not become a tool to stall national policy indefinitely, and that argument has weight. But even as strong arguments carry costs. And this ruling made those costs immediate, not hypothetical. So where does this leave us? It leaves us in a moment where attention matters, where understanding process matters as much as outcome, and where the phrase emergency ruling should trigger deeper questions, not casual acceptance. Because today it's this issue. Tomorrow it could be another. Different policy, different group, same mechanism, same speed, same shock. The Supreme Court didn't just decide a case. It demonstrated how quickly the ground can move beneath established expectations. And once people internalize that lesson, behavior changes everywhere, from courtrooms to boardrooms to kitchen tables. The real takeaway isn't panic, it's awareness. Knowing that legal certainty is no longer as slow or as stable as it once felt. Knowing that emergency decisions can now carry permanent consequences. And knowing that in a system where the rules can change overnight, the most valuable asset isn't prediction, it's preparedness. That's the shift this ruling represents. Quiet on the surface, massive underneath. And whether you follow law, finance, or simply your own future, it's a reminder that in today's world, the biggest changes don't always arrive with a warning. They arrive with a vote count, a timestamp, and a new reality you have to adapt to immediately.